In this session, we turn to the protocols under the Convention on Biological Diversity. While the international legal arrangement under the Convention on Biological Diversity, CBD for short, gave the framework at the global level, the two protocols under inquiry here give the flesh and blood to that particular frame. We start with the first protocol, the Cartagena Protocol of 2000, the Biosafety Protocol. Although this particular protocol, like the next one, was supposed to have been made in the year 2000, it came into effect only from the year 2003 when the required number of parties who affix their signature and ratify it started undertaking their obligations thus. And so, in each and every legal arrangement, we have a particular year mentioned of a kind of a commitment made by the parties who are going to undertake those obligations. But that commitment in the form of a signature need have to result in a particular minimum number of subscriptions in the form of ratifications to bring that into effect. And so the year of operation or bringing it to effect is quite different from the year when it is made. The convention under Article 19 refer to cooperation in research in biotechnology and equity in sharing of benefits on mutually agreed terms. It provided for conservation and sustainable use as the underlying principle, requiring to have an advanced informed agreement among the parties so as to ensure that there is safe transfer, handling, and use of any living modified organism, LMO for short, also referred to as genetically modified organisms or GMOs, that are the result of the application of biotechnology. So the protocol is designed to give effect to this particular provision of CBD as to require equity in sharing of benefits of research and in evolving effective safeguards to ensure biosafety aspects in particular. This was actually a concern. To address that, we have this protocol. It applies to transboundary movement, transit, handling, and use of all LMOs, living modified organisms, resulting from modern biotechnology that may have adverse effects on the conservation and sustainable use of biodiversity, including human health. For this purpose, there is a requirement under this new law of the parties entering into what is referred to as an advanced informed agreement. It's a normal contractual arrangement, but an agreement has to be entered into well beforehand before this technology transfer takes place. And it comes up with two separate set of procedures. Evolved for LMOs, one set for those that are intentionally to be introduced into the environment through research, collaborative research, or whatever, from one country to another. And second, those that are intended to be used directly as food or feed or for processing. And that is designed to provide necessary information needed to ensure that the importing parties have an opportunity and a capacity to assess the risk that may be associated with the living modified organisms before entering into an agreement, whether it is safe, where it's good for health, hygiene, well-being, human health, and similarly as to the rest of the environment. And all this would ultimately lead to an informed decision whether to get into that arrangement or not to have that import at all. And in addition, once you get into that kind of an arrangement, you should have to ascertain that whether I have the facilities available to handle in a safe manner. So it is not just a transfer of any commodity from one country to another. It's actually a transfer of genetic material and transfer of that material for technological processes and their application. And that would require quite a bit of caution to be exercised. And so the principle that's applied here is the principle of precaution in the entire process. And for this purpose, under this international arrangement, a biosafety clearinghouse is set up to enable the parties to exchange information in the manner as prescribed here. There is also a provision made for building of capacity in working this out and procedures for compliance by all the concerned. A lot of importance is given to making the people aware, making the people involved, participate as an important component of this prescription and the process. Because people should be in the know of things, of what is that they are going to consume, what is that is going to be put to application in the public domain, and then only it should become easier for them to take a clear, informed decision in that regard. So, a lot of caution taken. The party of import, despite all this, reserves this right. If there is a new scientific information about the risks or the horrors or the harms that are involved in the application of biotechnology with regard to this, then whatever decision it had taken earlier, it can review and change its decision even if it had entered into such an agreement earlier. It's part and parcel of this particular agreement. It's a kind of a safeguard that science, which is evolving over a period of time, may come up with new discoveries. That something which was considered harmless earlier has become harmful now. And so I should be able to revise my earlier decision. And so, in sum, this is a legal device that has been contemplated for enabling humanity to derive the benefits of modern technology. Because biotechnology has a lot of benefits. And so, this should be an enabling arrangement to facilitate humanity to derive maximum benefits out of it. But while doing so, under no circumstance it should compromise on safety, security, and integrate with the very resource itself and also that of the humanity. And so, for that purpose, this arrangement provides adequate and effective safeguard measures, which is anchor to the principle of precaution. That's in brief this international protocol on biosafety. We now move on to the other one, the Nagoya Protocol on Access and Benefit Sharing, ABS for short. The year of arrangement was 2010, and as was mentioned earlier, it came into force with the necessary number of parties subscribing to it on 12th October 2014. As of now, they have about 124 parties to this arrangement. This arrangement, the protocol, gives effect to Article 15 of CBD and also one of its objectives, namely fair and equitable sharing of benefits that are derived out of the use of genetic resources, GR for short. This is an expression that is used to describe every possible aspect of a bioresource and its components. It reaffirms the sovereign right of a state over its natural resources and that it stipulates that the authority to determine access to GRs vests with national governments. It recognizes and incentivizes practices and traditions of communities of people and also of everyone who is putting that into application of conservation of biodiversity. And this is one international legal arrangement which illustrates valuing biodiversity and ecosystem services. When you say biodiversity is invaluable, now there is one mechanism whereby its value is going to get determined through this particular process. Access for anyone is subject to what is referred to as a prior informed consent, PIC for short, of the provider country. So if an outsider wants to access your resource, you have to enter into a prior informed consent and an agreement which will incorporate this. And this agreement should be on mutually agreed terms. It's called as MAT between the provider and the one who is going to access it. On what are the terms? The terms is with regard to the sharing of benefits that you may get out of the use of this genetic resource, which is sourced from the providing country. And so, this establishes a clear framework for accessing the genetic resources and the knowledges associated with it, and in sharing of benefits arising from their use. So, the basic idea behind this is that if anyone wants to access the resource or the traditions, practices, and knowledges associated with it, he cannot take it free. So, this is one way of preventing biopiracy. Second one, when he takes it, it should be on a certain set of terms, mutually agreeable to the parties, so that equity is done. Benefits that are derived is shared and is not appropriated by the one who derives benefit to the exclusion of the one who provides that. That is the idea. That is the idea behind this particular arrangement. And the sharing of benefit, as has been mentioned here, may be in terms of money or it may be in even in non-monetary terms. And there is an annex that is added to this particular protocol, which comes up with a clear list of a non-exhaustive list of benefits to contribute to the conservation and sustainable use of biodiversity and its components. So look at the objective here. One is there should be equity. There shall not be any unjust enrichment for one who has taken advantage of a resource and the knowledges associated with it to derive some benefit for himself, to share it. And another one is that the benefits so shared is not something that is going to be squandered away by the one who got a share in it, the provider. It should be put to use for conserving the very same thing and for sustainably using that particular resource to provide perennial benefits. There are certain exceptions to this. That this arrangement is not possible with regard to human genetic resources. It is both unethical and illegal, and so you cannot get into this ABS arrangement at all on human genetic resources or genetic resources that are used as commodities in the normal use on a day-to-day affair. We use rice as a food, and this is normally being traded as a commodity in our day-to-day affairs. This cannot be made subject of matter of sharing of benefits. This is a normal thing. We should allow it that way, and it does not come under this particular arrangement. Or genetic resources that are derived from areas beyond national jurisdictions, like high seas, Antarctic. For that, there should be a separate kind of an arrangement. Anyway, its national governments are not the ones who are going to decide on how to use it or anything like that exclusively by themselves. Genetic resources annexed in the International Treaty on Plant Genetic Resources for Food and Agriculture, ITPGRFA for short, a separate arrangement, an international treaty entered into in the year 2000 One, those subjects are also kept out of this list because it's a separate arrangement for which separate access and benefit sharing arrangement is worked out on plant genetic resources used for food and agriculture. So these are excluded. The rest of it can come under this. And genetic resources that the home country determines as not require a prior informed consent, because you as a sovereign nation you can determine some of the resources that need have to be excluded from that, maybe for health reason, for the benefit of community of people or anything like that, or for any public purpose. The government has the power to decide that they do not require to come under this particular arrangement. So what is in brief the ABC of the access and benefit sharing mechanism? One is the obligation of access, A, access to share benefits. Then the second one is the obligation to share benefits, B, and C, the obligation to comply with these regulations. So, accessing, sharing benefits, and complying with these obligations is the ABC of this ABS. Very simple. And to ensure that there is some kind of an oversight in ensuring that these arrangements are done properly, transparently, openly, and this is made known, you have an oversight in the form of monitoring compliance provision. And here, every party to this arrangement is required to designate one or more effective, what are referred as checkpoints, for collection of information at any stage of R&D, innovation, pre or post commercialization. Like in each country, there are what are called as the patent office, that may be called as the checkpoint, or a custom authority, or a research funding agency. These may be designated by the national government as the checkpoint. It checks what is the kind of arrangement, how it is going to be effectuated. And so, storehouse of information to be made available for dissemination, this is the one that would do a kind of a monitor in the entire process. This can be put together in a tabular form from the provider country. The genetic resources need have to be transferred to the user country. The process is mentioned, and from that, whatever benefit that is derived need have to be shared, and this entire mechanism has to be notified to the ABS clearing house. That's an international certificate of compliance, and that constitutes monitoring the utilization of genetic resources. It also provides, it's a very ambitious arrangement, a very complex arrangement. And in addition to the sharing of benefits with the local community, with the national governments, it also comes up with another thing called Global Multilateral Benefit Sharing Mechanism, GMBSM, to address benefit sharing over genetic resources in a transboundary situation. So that will not come within the jurisdiction of any single state. Then you have to have an international mechanism that is being put together. But at the present stage, in the year 2020, it is still being evolved and not come to fruition as yet. But there is a provision for that. It also provides for supportive mechanism. How do you implement this? For that, a supportive mechanism has been put together. There is something called as the designation of national focal points. What is their job? They have to provide information and for coordination with the Secretariat of the Convention on Biological Diversity and competent national authorities for granting access. And there's something called as an ABS clearinghouse. It's more a web-based information exchange mechanism to share information. on domestic regulatory requirements. There is also provision for building capacity to support key aspects of implementation because there's something new that's happening and people need have to be informed, people need have to be equipped, people need have to be trained, and further provision has been made. And on the basis of the needs of nations, each and every country, especially developing country, and their priorities, some targeted financial support is also provided for through the Global Environment Facility. So, on the whole, what is this international legal arrangement about? The CBD and the two protocols. One can make out that this is a very unique law. The language that is used here is very, very distinctively different. There is nothing imperious in its appearance nor imperative in nature. It is essentially based upon cooperation amongst nations, and the parties make a collective commitment to give effect to this. So it is out of consent among the parties, 170 odd countries and 190 odd countries as of now, who have made a commitment to give effect to this arrangement. And in international law, there is a principle called something that has gone into the level of a peremptory norm of international law. That means if a large number of nations agree on something, it becomes a kind of a pole star, a guiding light from which there is no opposition, from which there is no violation possible. The question is, has this biodiversity law become such a kind of a peremptory norm? Well, there are arguments on either side that it has become on one side and it has not been so, but still it is very valuable international arrangement. In fact, this is one arrangement which makes a common cause of common concern of loss of biodiversity, and it displays the determination of community of nations to remain committed to conserve, protect, sustain life, and develop in an equitous manner. This is a law for celebration of life forms and ecosystems, and life support. This is a law that values life, recognizes the status, contributions, creates rights, and ensures reward of sovereign nations and also of communities of people. And it is a sovereign nation that exercises that right and enforces that. Really, a visionary legal document encapsulating the principle of precaution and sustainable development. It addresses the concerns of conservation and demands of development. But all these good things have not been actually realized for a number of reasons. And these are some of the outstanding concerns. There is a huge time lag. Remember that in 1992, the framework law was evolved, but in 2002, one protocol came, and in 2010, another protocol came, and they are still working out the nuts and bolts aspects of it. When time is of essence to ensure that the accelerated process of destruction and loss of biodiversity is occurring, the time consumed of nearly 2 decades in this entire process, or even more than 2 decades, is of very little help in making the law a very effective instrument of arresting the trend and restoring parity. Another problem with this particular arrangement is that there is semblance of an international monitoring, but monitoring by itself will not do. Monitoring coupled with enforcement, and that doesn't exist. And because of that, compliance is a bit of a casualty, and it compares poorly with other international legal arrangements. As you view this law in comparison with other laws that are developed at the international level, like the trade related intellectual property rights regime under the World Trade Organization, or the International Treaty on Plant Genetic Resources and Agriculture and Food of the year 2001, they have made certain inroads into this particular arrangement. And to that extent, it has weakened the ambit, the scope and effectiveness of this law, and it looks like a little bit of a helpless spectator before the more powerful other international arrangements. Another major problem is United States, which is actually the home to biotechnological applications. The biggest country, which has the biggest of laboratories in this regard, has decided to stay out of this arrangement. And that is a serious blow for an effective application of this law, especially with regard to biosafety issues. All said and done, a very important legal arrangement, and how this has been brought into application at the domestic level is a subject matter of our consideration in our next session.